Good morning.
We received an explanation yesterday of what a crime scene investigator does. And if you would give us the background that you have before you took the job in terms of your training, academic training for this position.
I have a bachelor's degree in forensic science from Baylor University in Texas, and I have a master's degree in forensic science from Marshall University in West Virginia.
So when you came to SLED, you had a pretty substantial, compared to others employed in your position in terms of the academic training. Is that correct?
That's correct.
And on April 4th, when you responded to Charleston, would it be fair to say you were the junior member of the crime scene team?
That's correct.
And the crime scene team from SLED was composed of you and Mr. Brown?
Yes.
And did you rely on anyone from the North Charleston Police Department to provide any services on behalf of your evidence collection?
Not to my knowledge, no.
And did you rely upon any one other than SLED to search the grounds where the crime scene was cordoned off?
Not when I was present at that location.
Do you know whether there was ever, can you tell the jury the type of searches that one would employ at a crime scene?
It varies from scene to scene, depending on the type of scene that we're at.
And they can be grid searches, can they not?
Yes, they can.
And a grid search would be dividing up the crime scene into different little squares or rectangles and eliminating one by one any evidentiary value of that location. Is that correct?
That's correct for that type of search.
And there are also line searches?
Yes.
And that would be that we could have anywhere from 2 to 20 officers walking the line and look for evidence.
That's correct.
Is that correct? And then there are spiral searches as well, correct?
Yes.
And that would be sort of like a snail's shell where you just keep searching things. Is that correct?
Yes, that's correct.
And are there any others?
I know there's a zone search where you can break certain scenes down into zones to search as well.
Now, given the geography of this particular area, which search was best?
I would say there'd be a number of those types of searches that would be adequate for that scene.
And which one was performed?
A search was not performed while I was there.
By anyone?
I can't comment as to whether something was searched before I arrived.
That search, if it had been performed, would have covered the entire crime scene to look for items that would contribute to the information you provided to the jury in your testimony today. Is that correct?
Yes, that's correct.
And we know, for instance, that the two projectiles that were found by citizens, not by law enforcement. Is that correct?
That's the first time hearing of it.
You didn't know that, I believe your testimony was that somebody who was associated with my office found the two projectiles?
Correct.
And nobody from law enforcement found those, is that correct?
Not that I'm aware of, no.
And the wooden fence that you showed on the photograph, just walking by that fence, you could see the defects, the holes in the fence, very clearly. You didn't need any instrumentation or anything of that nature to find them. Is that correct?
I personally didn't walk by the fence that day.
Did you ever walk by the fence? Did you ever see the defects in person?
Yes, I did.
And they're clear. I mean, there's nothing secretive or hidden about the defects in the fence. Is that correct?
That's correct.
And when something impacts a wooden fence like that, based on your training and experience, had you seen those, you would have known those were fresh marks.
That's correct.
And based on your training and experience, you would know that there was an entry hole and or an exit hole. Is that correct?
Yes.
So the photograph of the leaves, it was a lot harder to see the bullet in the leaves, correct, than it would be on the hole in the fence, correct?
That's correct.
But once one sees the hole in the fence, you'd start looking for further evidence, correct?
Yes.
And do you know the type of instrument that was used to find the bullets?
I believe it was a metal detector.
And do you know what type of metal detector it was?
No, I do not.
Do you know that it was a Fisher-Price toy?
No, I do not.
The point is, it wasn't complicated to find those bullets, correct?
Apparently not, no.
And in the crime scene itself, did you or did somebody under your direction or somebody you gathered with collect the taser wires?
Yes.
How many were there?
There was one cartridge that still had wires attached to it with 2 unattached wires, and another cartridge that had taser wire attached to it.
And did you examine those wires?
No, I did not.
Did anybody from SLED's crime scene, to the best of your knowledge, ever examine the wires?
No, they did not.
If they had examined the wires, they would see that the wire itself was covered with an insulator. Is that correct?
I don't know.
Have you seen the taser wires in evidence?
Yes, I have.
Have you seen other taser wires?
Yes, I have.
The taser wire in evidence is a typical taser wire, correct?
It appears so, yes.
And it has an insulation. Is that correct?
I'm not familiar with the taser terminology you're referring to.
A wire is conductive. Is that correct?
Yes.
A insulation is non-conductive. Is that correct?
Sure.
Is plastic a non-conductive insulator for wire?
I believe so.
Do you know whether or not the wires have insulators?
I don't.
Now, do you know the length of a taser wire that extends from the taser itself when discharged the full distance?
I believe there are different lengths associated with different models of tasers.
Did you know or do you know now the length of wire associated with the taser that's in evidence?
25 feet, I believe.
And has anyone measured the length of the wires in evidence?
Yes.
And tell us what the finding is.
I personally didn't measure it. Somebody from the solicitor's office had measured it at the lab.
The prosecutor's office?
I believe so.
Well, let me ask again, did anybody who's involved investigator measure?
Are you referencing crime scene investigation with SLED?
Anybody that you know of who's not in the prosecutor's office measure that?
No.
If the prosecutor had indeed measured it, there'd be some type of report or something that this jury could learn about how many wires were found. Is that correct?
Can you repeat that question?
Let me give you an example. Let's say that somebody testified that there were 4 wires found. Somebody could measure those wires to see really whether that's one wire that's been cut. If they know the length of what the wire was when it was discharged from the taser. Correct?
Yes, that's correct.
So that if somebody attempted to mislead someone else by saying there were 4 wires, when in fact that there was one, that's a matter that should be cleared up. Shouldn't it?
I object to him responding to this question.
The objection is sustained.
No question that the wires could be measured.
Yes, the wires can be measured.
And no question that the wires could be matched end to end where they were broken, if they were broken, to link those broken pieces together.
I don't know if they can be matched end to end.
No question that a wire could be looked at to see if it had been stretched, if the crimps in the wire have been taken out.
I'm not a taser wire expert.
What type of expert would it be to have to know whether or not the crimps in a wire are taken out?
I don't know.
You know that it's important in terms of evidence and the type of evidence this jury gets to see,
Sure.
but it just wasn't done.
No, it was not.
Now, with respect to the prongs at the end of those wires, how many did you or your colleagues collect?
Those are referred to as taser probes, and we collected 3.
And how many would there have been if the taser had discharged twice?
There would be 4 taser probes.
What effort was made to find the 4th probe?
I personally did not search for a 4th taser probe.
What effort was made by anyone? There must have been 30 or more people in the crime scene, correct? Law enforcement people.
At the scene, yes.
And which one of them got together and did a line search or a zone search or a grid search?
I can't comment as to who searched before I arrived on scene.
Which one of them took a metal detector, whether it's Fisher Price or some expensive one, to look for that probe?
I can't comment as to who searched before I arrived on scene.
What would have been the evidentiary value to this jury to get the complete information about this crime scene if the probe had been found?
It would have been helpful to find a 4th probe.
Because absolutely unequivocally, examination of that probe would say whether or not it was ever conducted electricity. Isn't that correct?
I don't know if that's correct.
Well, if somebody said that somebody was tased twice for a period of 10 seconds, if that had been argued by a lawyer in a case in front of a jury, there'd be proof of whether that's true or not. Isn't that correct?
I don't know if there would be proof of that being true.
Now, at the time of 12:06 on April 4th, you arrived at the North Charleston Police Department, correct?
Yes, that's correct.
And the purpose of your job, based on your training and experience, would be look for and gather evidence, information that would be helpful for this jury to make the decision they have to make. Is that correct?
That's correct.
And when you arrived at the North Charleston Police Department, the photographs that we saw earlier, Mr. Slager had already changed clothes. Is that correct?
Yes.
And Mr. Slager's weapon, had that been removed from him by the time you got there?
It was still present in the holster on his duty belt.
And when you arrived, did you put on those blue gloves we see to protect the integrity of the evidence?
Yes, I did.
And tell the jury why you do that as a crime scene investigator.
That's to prevent us from contaminating evidence that we come into contact with.
And it's not just you, anybody who touched it. If I was there that day and touched it, it would contaminate the evidence, correct?
Yes, that's correct.
So, do you know how many people touched the taser without gloves before you obtained possession of the taser?
No, I do not.
So, you took the taser and you examined it or you performed a test on it to identify who may have touched it. Is that correct?
I swabbed the taser for touch DNA, yes.
And the purpose of doing that is to identify who had touched the object. Is that correct?
The purpose of that is to potentially develop a DNA profile from the object that's swabbed.
Tell that in layman's terms, if you would, to the jury. What does that mean?
The taser itself was swabbed, the entire exterior of it, and we hope to develop a DNA profile from touch DNA, which are skin cells left over after somebody has handled an object.
And the particular touch DNA means skin cells, is that correct?
Yes, that's correct.
Before you examined it for skin cells, did you examine it for sweat or blood or any of the body fluids?
I don't examine things for sweat or skin cells. They're swabbed, but I don't examine them for that.
Did you look in the crevices of the handle to see whether there was any blood in those crevices?
No, I did not.
And we know that that would be a different type of DNA examination that could be done if in the grip of the handle of the taser there was evidence from somebody, either blood or sweat, correct?
If blood had been present on the taser would have been swabbed differently.
And that examination, a visual examination of a dark object, does not necessarily say whether or not blood is present or not, correct?
That's correct.
But there are means, different light sources that can illuminate the blood if there was blood on the taser, correct?
Yes, that's correct.
And that wasn't done.
No, it was not.
There was an assumption made that there was touch DNA, correct?
No assumption was made. It was just swabbed to see if we could develop something from the swabs.
No question that before the examination took place, you were aware that there was a struggle, not just between bodies, but a struggle over the taser, correct?
That's correct.
And no question that that Officer Slager had actually demonstrated to Chief Griggers what happened in terms of the struggle at that point. Were you aware of that?
I was not aware of that, no.
So it wasn't passed on to you that there was a physical struggle over the taser?
That portion of...
Objection's overruled.
Were you
It's
aware
either
that
yes or no.
Can you repeat the question?
part of your evaluation of evidence is based on your knowledge of how that evidence applied to the case? Is that correct?
Yes, that's correct.
So that if you were aware, and I don't know whether you were aware, if you were aware that there was a struggle over the taser, that would direct the processing that you employed on the taser. Is that correct?
Yes, that's correct.
And did you know that at the time you examined the taser that there was a struggle over the taser?
Yes.
And are you aware on the surface of the taser that there many areas suitable for fingerprints. Are you aware of that?
There are some areas on a taser that may be suitable for fingerprints.
I approach. You see the taser?
Right
Hot, warmer, colder?
there. Thank you.
I'm looking at State's Exhibit 49. Agent, if you would remove it from the package.
I'm sorry, can you say that again?
I'm sorry. Would you remove it, State's Exhibit 49 from the package? So if you would, I heard you mention this morning that the red portion of that is really not part of the taser, is that correct?
That's correct. It's a safety clip.
So does the taser have a battery in it now?
I believe so, yes.
Can you remove the battery and then remove the safety clip, please? So if you would stay right where you are, would you show the jury the operating end, that is if somebody were to be drive stunned, the area of the taser that would touch the person who was drive stunned?
Well, it depends whether or not a cartridge is attached to the end of the taser.
Assuming that the cartridge had been removed.
It's this end of the taser that would be in contact with an individual.
Does the taser you have in front of you now, State's Exhibit 49, have a cartridge on it?
No, it does not.
So that what you're just showing to the jury would be where one would look for DNA if there was an allegation that somebody had been tased. Is that correct?
Are you referring to the front end?
Yes, the business end of the taser.
Yes.
And if somebody said that there was a struggle over the taser, where would you look for DNA?
I don't look for DNA, I swab for DNA.
Where would you have swabbed if somebody had indicated that there was a struggle, if you would point the taser, it's unloaded. If somebody, you were holding on to it and I was trying to take it away, where would you look? Where would you swab for DNA?
In the example that you just gave me, I would swab the portion of it that you had touched.
If somebody had used the taser, where would you look? Where would you swab for DNA?
The handle portion and also the trigger.
And where on that device would you look for fingerprints?
You could look at the entire exterior surface for fingerprints. However, this surface is not usually conducive to maintaining fingerprints.
And that is because it has a waffle-like surface, is that correct?
That's correct.
Look at where it identifies itself as an X26,
Yes.
if you would show the jury where that is.
It's on two sides.
And that's where if somebody tried to struggle over the taser, that's the particular area that would be held. Is that correct?
I can't comment as to where something may or may not be held during a struggle.
But no question that fingerprints could be retrieved from that area, depending on the circumstances.
They could be retrieved from that area, yes.
Now, certainly fingerprints and DNA can be obtained from the same object. Isn't that correct?
That's correct.
So when one investigates, one gathers the evidence that hopefully a jury would see someday, there's a method and a process to determine what would be non-destructive testing, leading at the end to more destructive testing. Is that correct?
Yes, that's correct.
So is DNA destructive?
Not how this was swabbed, no.
Is fingerprinting destructive?
Some fingerprinting processes are destructive, yes.
So in this particular instance, we could do DNA, complete that, and then move on to fingerprint testing. Is that correct?
Not for this particular item, no.
Why not?
With this particular item, given that it is black, for fingerprint processing to be done, it would have had to be superglued inside a chamber. Cyanoacrylate fuming is what we refer to it as. And there is a potential that that could have destroyed the functioning of the taser.
All right, well, the function of the taser, that would have been destroyed.
Yes,
But you could have done DNA first, correct?
yes, that's correct.
Wouldn't have done anything to the taser. You could then check the functioning of the taser, wearing the gloves that you have on, preserving the evidence in its best state, and then determine at some later time the functioning of the taser. Because all things aren't done at one time, correct?
That's correct.
Staging, you do the first test, and the second test, and the third test, and on and on and on. Correct?
Yes,
There was no reason in this case not to do both DNA and fingerprints. Is that correct?
the taser was swabbed because the surface is not conducive to latent prints.
Even though you just said where the X26 is a suitable area.
That is an area that may be conducive to latent prints, but we don't spot process.
And there's also another area on the handle that's suitable for latent prints. Is that correct?
There is a possibility that surface may maintain fingerprints.
But possibilities only turn into reality when they're tested. Your statement of possibility is only possible because it wasn't tested. If it had been tested, then it would be probable. It would be absolutely this surface wasn't good or whatever reason you want to use. When there are possibilities in the science of evidence collection and examination, everything's possible. Correct?
I can't comment as to whether everything can be possible.
Well, possibilities only turn into reality when they're examined. Is that correct?
Yes.
And this item was not examined.
For fingerprints, no.
Well, let's talk about DNA. How many swabs did you use to collect DNA?
2 swabs over the entire exterior surface.
And would you show the jury, please, where you swabbed on that case?
It would have been, again, the entire exterior surface to include the trigger inside, the handle, the back portion, the top.
How about the business end of it?
I don't recall having swabbed the business end of the taser.
So when you say you swabbed the whole instrument, the business end where it would have touched somebody, if it was used against them, was never examined.
I wasn't aware that this end had touched somebody.
The 2 swabs that you took of the taser, do you know what happened to them?
After the item was swabbed, the swabs themselves were dried and given to Agent Brown.
And those swabs both took DNA in the same areas on the instrument on stage 49. Is that correct?
I can't speak as to what areas of the swabs were looked at.
As far as the swabs, you did the swabbing.
Yes, I did.
Did you do swabbing with one Q-tip on one side of the instrument and then put that down and pick up another swab and do the other side of the instrument?
No, it's 2 swabs held together over the entire surface.
And when the swabs, the 2 swabs got to the lab, they were combined to discover what DNA might have been there.
They've always been combined.
So if you had 4 or 6 or 8 or 10 Q-tips and swab different areas of the taser, they could maintain segregation until they got to the lab, and the lab could have combined the 2, 4, 6, 8, or 10 swabs to obtain DNA. Exactly.
I don't know if they combine swabs in that fashion.
Well, you had indicated in your testimony earlier that you were afraid that there wasn't sufficient quantity of DNA, and that's why you swabbed the whole instrument.
That's correct.
Are you aware that swabs can be combined in the laboratory so that there wouldn't be any reason to use one swab over the entire instrument?
One swab was not used over the entire instrument.
The 2 swabs that were used together were used over the entire instrument, correct?
Yes.
Were you aware that you could have used different swabs in different locations, even with a minute amount of DNA, to be combined with the lab to make it suitable?
I'm aware that you can use multiple swabs in multiple locations, yes.
But that wasn't done.
No, it was not.
And you know that the DNA that was found by the lab on that taser was Walter Scott's. Correct?
Yes.
And you know that the greatest quantity of DNA found on that taser was Walter Scott's.
I don't know whose quantity was greater.
And this is a murder case. This is a murder case.
Yes, it is.
Most serious case that can be tried in this court. Correct?
That's correct.
Now, when you went to the North Charleston Police Department and you photographed Mr. Slager, Officer Slager, were you aware that he had already washed his hands, cleaned up the wounds that he had? Either he personally or somebody else had applied medication, treatment, cleansing material to those fingers?
I don't believe I was aware of that, no.
Did you ask?
I usually ask before performing a gunshot residue kit if somebody has washed their hands prior to taking the kit.
I'm talking about the areas where he was bruised, the area that was still bleeding when you got there. Did you ask if anybody had provided medical attention to those areas?
No, I did not.
And the photographs that you took don't seem to indicate bleeding. When were they bleeding when you saw them?
He actually bled on my chain of custody that he filled out for me.
And between the chain of custody that he filled out for you and the time you took the photographs, did somebody apply some medical treatment to those injuries?
Not that I'm aware of, no.
Even looking at your photographs, you know there were other photographs. Did you take the other photographs?
Which other photographs are you referring to?
you recognize this photograph?
Yes, I do.
Is that a photograph you took?
I believe so, yes.
Does it accurately reflect, depict the image in the photograph at the time that you took the photograph?
Yes.
John Woodall, this is State's Exhibit number 18.
Without it.
It's admitted without objection.
The photograph that you put, that you identified earlier when the solicitor asked you about the photograph on the hand, could we put that back up? Photograph of the hand.
Is it one of these?
Yes. What number is it?
142?
The picture that you just identified as Defense Exhibit 18, could you put that up, please? John? Well, from looking at Defendant's 18 that's in front of you, here it is now, and the photograph that you previously displayed to the jury, is there a difference in the two photographs?
In reference to?
The injuries?
Your Honor, just as before, they don't appear to be the same. Defendant's 18, so, certainly, that doesn't appear to be defendant's 18 that showed it to me. Am I correct? Is there anything like that? It's not the same photograph.
Well, they look for that. Let's talk. When you went to the North Charleston Police Department, you took photographs of Mr. Slager. And you obtained his shirt and you obtained his pants, correct?
Yes.
And did you obtain those things that hold the shirt in line, in place? Did you obtain that? Whatever the garter belts or whatever, that hold the shirts tight.
No, no, I did not.
Did you obtain that?
No, I did not.
Did you obtain his duty belt? Which is what we see in law enforcement, the big thick belt and handcuffs and all that. Did you obtain that?
No, I did not.
Did you obtain anything other than the shirt and pants, no shoes, no duty belt, no anything else, what they call assets, the assets that he carried that day? Did you obtain any of that?
No, I did not.
And of course, as an evidence collector, there may have been some evidentiary value in that to show that there was a struggle, correct? You knew from looking at the uniform that there was dirt all over the uniform. You looked at his injuries and realized that there must have been some type of struggle that was employed that morning. And wouldn't it be logical then to obtain the duty belt to look for evidence of scrapes or scuffs or perhaps bodily fluids?
That could have been done, yes.
It was not done.
No, it was not.
It was done later, though, wasn't it?
The duty belt was collected later, yes.
Because somebody realized a couple of days later that, hey, we overlooked this, and went back to get the duty belt, correct?
I was not aware while I was at the police department that a request had been made to collect the duty belt.
You didn't make that request,
No, I did not.
and you're the crime scene evidence technician that gathers evidence,
I was at that location, yes.
and you didn't ask for the duty belt.
I did not know.
You didn't ask for the radio.
No,
You didn't ask for the microphone that was used that day.
no.
Now, how much later was it that somebody tried to obtain the duty belt, the radio, the microphone, the vest that Mr. Slager was wearing that day?
We've never been in possession of the vest.
How much later did SLED try to obtain the vest?
To
How
my-
many days in between the event and the time that somebody said, hey, we better go find stuff?
I don't know how many days afterwards